transfer of property is done by the act of parties or by operation of law. Usually it is most of the property transactions that we see are done by the contractual act of the parties, which is governed by the Transfer of Property Act. So the Transfer of Property Act covers 5 types of transfers, which is sale, lease, exchange, gift and mortgage. Okay. Now sale is the most common type of transfer, where the property is ownership of the property is absolutely transferred from the seller to the buyer. Okay. Now this is a document that requires to be compulsorily registered under law. Okay. Now lease can be either by way of a registered document or by way of unregistered document as per the Transfer of Property Act. If it is a lease exceeding 1 year, then it has to be compulsorily registered. Now we see standard sentiment in the market is that if you are doing a residential lease, which is usually called as a rental agreement, so it is done for 11 months. So this is mainly to avoid the process of registration. So whether it is a residential property or a commercial property or industrial property, any lease which exceeds 1 year has to be compulsorily registered. Again, each state may have its own laws, because there are some states which require all leases to be mandatorily registered. So before taking a decision on whether it is registrable or not, we will need to examine the respective state law. Mortgage is a document which is done to create a charge or an encumbrance on the property, and we will come across mortgage documents where a property is offered as security for a loan which is obtained by the owner. Again, within mortgage there are different types, and these are mostly used in banking transactions, but it can also be done between two private individuals or parties. A gift is a transaction where a property is transferred by the owner, who is called as a donor, in favor of another person, the recipient, who is called as the donee. And the characteristic feature of a gift which distinguishes it from other types of transfer is that it is done without any monetary consideration. Whereas for the other types of transfers which are governed under the Transfer of Property Act or under any other law, like which is whether it is a sale or a lease or an exchange, etc., it has to be backed by a consideration, offer and acceptance. Whereas a gift is a transaction which is done without any monetary consideration, and usually it is a method adopted to transfer the property within the family in order to avoid disputes. And if a gift is done within the family members, then the stamp duty is nominal. Again, stamp duty is a state subject and it may differ from state to state, so it is advisable to ascertain what is the applicable stamp duty in a particular state, and it could also differ from city to city. So there are instances where property situated within a municipal corporation jurisdiction may attract a higher stamp duty, and a property situated in a tier 2 city or in a village could attract a lower stamp duty. These are granular details which people will have to ascertain before completing a transaction. But a gift, in order to be valid, has to be recorded in writing and it has to be registered, except in the case of Muslims, where under the Muslim law an oral gift is also valid and acceptable. Okay. Now apart from this, we also see that and there is another type of transfer which is under the Transfer of Property Act, which is exchange. So exchange, as we know, is, I think it stems from one of the oldest method of doing business that we have seen in mankind, which is barter. You trade one for the other. So instead of a monetary consideration, a person may choose to transfer one property and take some other property in return. But it is not necessary that both the property should comprise immovable property. One could also transfer an immovable property in return for a movable property, such as I can choose to transfer my immovable property in favor of my friend and take a fancy car, or take shares in return for that. So long, and it is also not necessary that the value of both the transactions should be the same, or both the properties which form part of that transaction should be the same. But the stamp duty for a exchange deed will be determined based on the higher of the two values. property A versus property B, whichever has the higher value, on that the stamp duty will be determined. And again, these stamp duty registration are all state subjects, and one needs to understand the applicable duties in the particular state. Apart from this, there are other ways of transferring property which could be by operation of law, such as by inheritance. If a person dies without making a will, then the property will be transferred in favor of the legal heirs by operation of law, that is the law of succession. And that again will depend on the personal law applicable to the parties. Hindus are governed by the Hindu Succession Act. We have the Indian Succession Act, which governs Christians and other communities, and we Muslims have the Muslim personal law. So depending on the law that is applicable to the concerned person and the family, we will be able to ascertain how the devolution of the property by way of succession will take place. And there are other means of transfer by way of operation of law, such as in case of a company, you could do it by way of a merger or a business transfer asset. There is another way of transferring the property, which is by way of a will, but that will come into effect only after the lifetime of the person who is making the will. And there is one other way of transfer, but which is more by way of a compulsory transfer, and that is where a government may acquire the property. Or there could be instances where a person is required to relinquish a property in favor of a government authority or for a statutory authority, and these are again stemming from certain laws. Where there is compulsory acquisition, the government has to determine a compensation which is commensurate with the market value of the property or slightly higher, depending on which enactment of statute the acquisition is done under. And through the process of law, after completing the steps for the acquisition and payment of compensation, the government can take over the property. So this compulsory transfer will come into effect only where the government is choosing to acquire the property. But there could also be instances where government transfers the property in favor of certain people, and these are called statutory grants.